I'm going to give your lordship say written submissions in the form of extracts are also
Yes,
there.
sir.
Everything is at one place.
Yes.
And uh, I'm going to read some parts of it, but I'm going to just develop the nuances of some principles of law. Your lordship may not find it in the sequence in which it is argued, but I'm going to be rejoining to each point,
Yes.
but in a different sequence.
Yes.
Your lordship may not possibly get the answer to a particular question in the sequence your lordship expects it, but I'll do it in that way.
Yes.
And I will deal with all the issues raised. But let me at the outset, before I hand it over, give your lordship a summary of what I want to sketch out, and then let's continue in that line, in that sequence. Well, it's the first part is, of course, to keep in mind the backdrop of the umbrella of statutory protections provided, especially to an elected public servant, paving the way for an inquiry or investigation, which has very serious implications of diluting or unseating or creating a mandate contrary to the election. So that has to be interpreted in that contextual manner. That it is not just a walk-in, walk-out system. There must be a proper protective umbrella which is given its proper full letter and spirit. Implementation is a general backdrop point. Now, the other part which I will develop, I'm just giving a summary, is that it is a mistake to suppose, by just citing MP or one or two judgments, that the moment any government minister or chief minister is involved, automatically this very well and old and long established jurisprudence about governors having extremely limited circumscribed powers to act in their discretion, so-called discretionary powers, is automatically overridden. So the Constitution says, and Shamsher Singh remains the bedrock, says that the discretionary so-called exceptional powers of the governor are so limited and so specific. You now read onto it a proviso which is not there anywhere in no case law, and it's a misreading of both Shamsher Singh and of MP to suggest that there is. You engraft upon it a proviso to say the moment automatically, and I repeat the word automatically, a chief minister is involved, you must assume that the advice of the council is biased and engraft the discretionary power. That is not what either Shamsher Singh, MP says. Does not. It's a much more nuanced law. The nuance is that the law remains the same. The governor has no discretion because it is not part of his list of discretionary powers. Obviously, we are not dealing with the discretionary powers. Those are different areas. So in the normal course, the governor has no power. However, if it is shown, and the word shown is important, that in a particular case of sanction, the order denying or recommending no sanction suffers from transparent apparent bias that is to be demonstrated. And the second thing was completely forgotten in the respondent's arguments in the manifest irrationality. So there's no auto. But I come, it's a slotting machine, I'm a chief minister, there is a cabinet, therefore auto. MP, you must straight away ignore, and the governor is free to act. No. The governor has to demonstrate that I am now acting in my discretionary powers because of this apparent shown bias. Shown means prima facie shown.
Yes.
And second, where there is no bias shown, and this is one case, and MP is very interesting, not a case of bias at all. The case went on, the demonstration that this order suggesting no sanction, words are, is manifestly irrational. Once you demonstrate that, then your discretionary powers come in, is the nuance point, much more nuanced than the generality of what was argued. That look, I have told you, this is a cabinet, this is a chief minister's case. No such concept. We state of apply. That I'll be demonstrating, Manas. The third aspect I'll be demonstrating is that your lordship has a very interesting order. According to this short point, which I'm now saying, is sufficient to set aside the order. I'm not saying your lordship will set aside on only one point. I'm just saying it is sufficient. It's so important, and it should be given its due importance. Well, it's without prejudice to what I'm saying about the nuance of Shamsher Singh and MP police establishment. Without prejudice to that, the entire 5-6 page order of the governor, impugned, is only on one point. I am deciding independently. I am not bound by you, the order. Entire, I repeat. So the most important part of this case, if your lordship were forced to single out the most important part, is that for a minute, if your lordship accepts that he is not bound, without me conceding at all, I am always very heavily opposing it, but that he is not bound. The governor has not gone beyond those 5 pages to add a word as to how, not being bound by these people, I find how, what, when, or where the CM is complicit, prima facie, and therefore I grant sanction. His role, that is the CM's role in this file, the CM's decision on that day, the CM's ministry on that portfolio, the CM's file noting on that particular event, nothing is to show prima facie complicity, but I grant sanction because I'm not bound. The Honorable Governor, therefore, commits a very serious constitutional sin of answering a very important constitutional question by the answer, why not? The Constitution asks him to say why, not why not. Your lordship knows what is the why not versus why.
Yes.
You, why not grant? We'll see. Sorry, that's not the constitutional thing with this. You have to show affirmatively why your lordship should be. Your lordship doesn't decide matters by saying why not. We allow or why not we dismiss the petition. Your lordship is forced to give reasons for this as to why. So that's the test. On this short point, Wallace, the impugned order is liable to be set aside because it does not address the question. It does not deal with it.
No,
Now, the fourth point.
One clarification.
Fourth
sir.
point.
You said that the governor has passed the order without arriving at a conclusion that the cabinet was biased, or without even observing
Without any
cabinet
material.
without any material to
He
show
says
that
it is, I'm sorry to interrupt, my lords. He does say, this part he addresses. The
Yes.
other part, he does say, the cabinet is ultimately the cabinet headed by CM, therefore it must be biased.
So no, he presumes it to be biased.
I'm very
is what-
grateful.
is
Presume
what
the
you
right
say.
word.
Presumes it to be biased. There's a concept of unconscious bias or subconscious bias.
Maybe.
Now, which cabinet will tell their leader to be proceeded against?
Well, it's-
Which cabinet will approve, saying that yes, he is our chief minister, governor has sought opinion of the cabinet, and this cabinet is going to permit sanction or approval for proceedings or sanction for prosecution. Which cabinet will do that?
So what
Which
was-
cabinet will go against their leader?
Well,
So if not apparent bias
yeah.
or rational apprehension of that bias may have led,
May
but
I-
that should be reasoned out. Is what?
May I answer?
Yes.
So first part is not reasoned out.
Yes.
First part is that. But second part, your lordship query is more important. Well, then, if your lordship were to accept that as a principle, then it is a case of presumptive bias. Then your lordship is not doing, kindly see what your lordship is really doing. I'm answering my lord's query on an argumentative basis. My lord has put a very important
No, there
question.
was a clarification.
No, it's a very important question. But just see, suppose your lordship's formulation as a question
only
to
a
me,
clarification.
only to
What-
elicit from me. Suppose your lordship's formulation was correct, just for a minute, just obviously your lordship is not giving any, your lordship is only
That's true. sir.
discussing. Suppose the lordship formulation was correct. It would mean exactly what I said in the previous sentence.
Why not?
Presumptive assumed bias in every case. Well, let's tell me which case your lordship will have of a sanction where your lordship will not have to apply this principle. But the law, the constitutional law is not that. Because your lordship then has the moment, then what is your lordship doing? Then my lord has in the constitution, A, B, C, D are only 4 discretionary powers of the governor. My lord is making this a fifth category. Always. Always. Then, Malus, why does MP go on? MP, Malus, doesn't go on the bias. If presumptive bias was correct, it had to be finished. It goes by analyzing that the reasoning of the cabinet is not right. It is manifestly irrational. And it is not irrationality, manifestly irrational.
A little higher
I-
pedestal of
I'm very
irrationality.
grateful.
Like how it is arbitrariness and manifest arbiter.
So, Malas, I'm very grateful, in fact, for the clarificatory question. The only case chosen by the Honorable Governor to cite is MP. But I've analyzed MP very carefully now, Malas. I Malas, hate to say this, but possibly the Governor has not been assisted sufficiently, he's not a lawyer, to analyze it equally carefully. MP does not go on bias, which answers my Lord's query, because in every case of a cabinet and every case of a governor, then MP must be read to mean it's a sixth category of discretionary power of governor. MP doesn't say so. Secondly, if my Lord's Malas, the clarificatory question was correct in the conclusion, then there will be no manifest irrationality. Which governor needs to go to manifest irrationality, Malas? Doesn't need to. Your Lordship not to waste your Lordship's time to go to manifest irrationality when
No,
it's
not
a
necessarily.
presumptive bias.
It was only a
Presumptive bias.
clarification that.
No, I'm not saying your Lordship, I'm answering your Lordship's question. The governor doesn't have to waste his time. If he has, well, why should he examine manifest irrationality? So suppose, Balas, and there are two categories. One is, Balas, your Lordship has given me the category where which cabinet will go against. Of course, Balas, in politics there are enough cabinets which go against people. It is not, Balas,
It is
so sanguine and so uniform as your Lordship might think, Balas. These are very turbulent waters,
no.
to put it mildly.
Yes, sir.
But that apart, your Lordship is, Balas, not looking at the other aspect which my learned friends will, my learned friends are not looking at the other aspect which your Lordship will appreciate. That, Balas, cabinet, if it gives, forget this case for a minute. I'm testing your Lordship, Balas, the proposition. If, Balas, the cabinet in a hypothetical case gives perfect reasons, right, Balas? It says this chief minister has done nothing.
No, that's what the cabinet noticed
No,
in the case.
I'm not saying my case. Forget
Yes.
my case.
All right. Hypothetical.
Hypothetical case, that this cabinet has said that this chief minister is always sitting at a 10-mile distance from all these decisions over 20 years. But in fact, it's a very unusual case. I mean, I'm going to be delivering all this. It's a very, very interesting case, Manas. 23 years. More than 23 years, at least 23 public servants must have been involved in this. The list of dates your Lordship has got from my side and this side.
Yes.
One person is singled out by these complainants, 3 complainants, with somewhat dubious antecedents sketched in my petition. One public servant is culled out after 20 years. And in those 20 years, this man, Malas, has been a minister